Right, thank you. Let me therefore begin swiftly since time is not on our sides. I thank the organizers, especially Regina, for organizing this and inviting me to speak. It's an honor and privilege to be able to do this. I consider it absolutely my loss to have not been present earlier this year to have done this with everyone. Having said so, I'd like to now share my slides and hope that these shall be visible. Um and here we go. Right. This paper is talking about something that is has become a recurrent issue in international courts and tribunals, and this paper specifically talks about one of those issues that has arisen between Russia and Ukraine. Uh, in this particular matter, what starts happening is that there are issues related to the suppression of financing of terrorism and the weapons that are being sent, especially in regards to what happens here and after as well. This case discusses the intricate overlay of the frameworks and relationship therein between terrorism, radical and racial discrimination, human rights violations. The paper, as perhaps will become evident as I speak further, is to provide an analysis of how the legal domains impact the enforcement and realization of states and also their understanding. Perhaps, in some sense, what I am referring to is legal warfare, or in some sense, legalese, because this treatment of international law as a means of furthering a political objective has become not only just a trend but a recurring theme in the practice of international law in quote unquote welfare issues that perhaps might not even affect those parties involved. Having said so, this case and also this matter talks about the Russia Ukraine crisis and the case between the International Court of Justice, which discusses this at great length. What about background and context, and can that in some sense offer some sort of an understanding of what we wish to discuss? Well, on the 26th day of February 2022, is 48 hours subsequent to the assaults perpetrated by Russia in Ukraine, Ukraine lodged a complaint or an application to initiate proceedings against Russia before the International Court of Justice. The crux of this dispute was delineated as pertaining to the interpretation and application of fulfillment of the 1948 Convention on the Prevention and Punishment of the Crime of Genocide. Now, what was interesting here was that Ukraine chose not to predicate its claims on the prohibition on the use of force as per Article 2.4 of the UN Charter. The strategic rationale behind Ukraine's objective and invocation on the interpretation and application of the Genocide Convention lies in its reliance and relevance in the conflict and the backdrop of this. This is the point that we shall return to later on in the presentation, and it chimes well with the understanding of warfare in legal issues. However, the issue perhaps requires further deeper understanding as well. To that end, it must be said that the alleged perpetration of mass killings of genocide against individuals of Russian ethnicity in Donetsk and Luhansk regions, also known as Donbass, situated in eastern Ukraine near the Russian border, are those of critical importance in this matter. Russia cited Article 51 of the UN Charter to rationalize its use of force, contending that it was acting in collective self-defense to safeguard the populace of Donbass from the purported genocide taking place on these very individuals. Russia therefore also acknowledged that the autonomy of the two regions designated as the Donetsk People's Republic and the Luhansk People's Republic. Ukraine, of course, challenges these issues in the court itself and holds that these regions and also the claims of genocide and perhaps most importantly this special military operation challenging these very issues is something that requires deeper deliberation by the court. The Ukrainians also asked the Russian Federation through the court that it must furnish assurances and guarantees for non-repetition, as of course time has passed and we have seen such requests have fallen to deaf ears. Having said so, there are two primary concepts that come to light in the Ukrainian submissions. First being that the court is urged to answer an adverse declarations affirming the absence of genocide perpetrated by Ukraine. Secondly, a constructive determination was sought, asserting that the Genocide Convention prohibits resorting to military measures for forestalling of genocides. Now, what becomes critically clear from this is the Ukrainian approach is somewhat innovative. It nevertheless was not the first instance that Ukraine employs this strategy in a dispute with Russia. Remember 2017 in Crimea. Because in this instance, Ukraine had also filed a lawsuit against Russia, alleging violations of the International Convention on Suppressing of Financing of Terrorism and the International Convention on Elimination of all forms of racial discrimination. What happens therefore after in the hearings on the provisional matters is also interesting, because Ukraine invokes the sentiments that were buried after the Second World War, when Europe promised itself and the world never again. We see this widespread commission of war crimes taking place nonetheless. Lastly, perhaps most importantly, Ukraine also asserted that the adverse environmental consequences must bear reference. However, Russia's interpretation is contrary to the Ukrainian assertions, insofar as to construe that the acts don't fall within the meaning of the 1948 Genocide Convention. Russia's arguments perhaps can be challenged on Russia's use of force, which fall outside the purview of the convention, and secondly, that the military operation orchestrated by Russia was not predicated in the convention, but rather in the right of self-defense. Of course, Putin's references to genocide were deemed general and insufficient to establish a strong basis for framing of the issue. Now, having said all this, it is perhaps important to understand that court under Article 49 of the statute understands all these issues, but also knows that Russia's invocations of collective self-defense under Article 51 of the Charter as justifications for its actions in Ukraine did not detract from this, and that an obligation noted that a single act or omission could fall under multiple treaty obligations. In this instance, the court therefore acknowledged that since 2014, various Russian state entities, high-ranking officials, in official discourse and UN forums, even before initiating criminal actions against top Ukrainian leaders for alleged breaches of the Genocide Convention. What becomes interesting is the matter when it pertains to the merits, because insofar as the merits are concerned, the plausibility test is invoked. And here the court notes that the evidence provided is insufficient to establish the acts of genocide and the acts that have occurred within the Ukrainian borders. The court had previously emphasized that in other cases it is important to use the plausibility right, and which is not subjected to the military operations by the Russian Federation aimed at preventing, punishing, and alleged genocide on its own territory. The court also linked the Ukraine's right for plausible rights under the Genocide Convention directly to the provisional measures as requested in Ukraine's appeal. Regarding the condition of irreparable harm and urgency, the ICJ found these conditions to be met. While some judges, like Judge Robinson and Judge Dode, they argued that this non-aggravation order should have been directed solely at Russia, and the court opted for a more neutral stance, potentially reflecting a strategic balance approach to prevent any escalation of hostilities, which underscores the court's commitment to fairness and equity. However, the toothless nature of international law indicates something for all of us. Having said so, the court's provisional measures, going back as far as to the cases of Legrand, Navina, and Jadhav, indicate that the provisional measures as well under Article 94 of the statute have a nature. Of course, the Security Council is also a route, but that route shall not perhaps bear further discussion given the limited nature of this discussion. And knowing that I will be testing your patience further and further, what I would like to share is that from the Ukrainians' perspective, the attack were the results of Russia's abusive exercise of the rights of denounce and prevent genocide clearly outlined in the convention. The allegations of rights of abuse have taken place From since then situation, as Ukraine observes, Russia distorted the scope of its rights under the convention and exercised them in stark disharmony with its objectives and purposes. Another issue for final determination is permissible means for preventing potential genocide, while all intervening states, of which there are many, includes international criminal law and also other consensus between preventive measures. These issues also touch the delicate subjects of humanitarian interventions in the context of genocides. Some states have also expressed a willingness to accept unilateral interventions when there is a solid evidence of genocide and collective measures that are failed. However, from a jus ad bellum perspective, an attack remains unlawful even when aimed at preventing genocide, while a good faith analysis may mandate a duty to prevent genocide. It does not, however, create a corresponding right. Having said all of this, it perhaps is important to return to the most preliminary remark that was made in this presentation, and that is that besides the ICJ, Russia and Ukraine have been fighting it out in the European Court of Human Rights, the Court of Justice of Europe, the International Tribunal for the Law of the Sea, ICSID cases, amongst many others. However, what becomes clearer and clearer is that the issue sees no light at the end of the tunnel. These issues continue, and so does the war. Years into the conflict now, Russia has not acknowledged the interim measures from either of the ICJ or, say, for instance, the ECTHR, casting these decisions as potentially symbolic. This raises the question about the effectiveness of lawfare in armed conflicts. Is this strategic advantage or a risk to international law's very existence? All of this remains to be seen, but perhaps for now what can be said is as follows. Despite its effectiveness in issuing decisions, the enforcement of these decisions appears illusory, a reality that could undermine the credibility of international law. The international community's apparent resignation of this inertia may be perceived as a proof of a flawed system. However, the symbolic power of these judgments remains significant in the international sphere, affirming these widespread actions of condemnation and these attacks. With those words, I thank the organizers once again for giving me an opportunity to share my thoughts and perspectives. It's been an honor and a privilege to share those, and I remain open for questions. Thank you.
Recording stopped.
Thank you so much, Ankit. So we have just